Good afternoon and welcome to the Court of Appeals. We have two cases on our 1:30 docket and a third case on our 2:30 docket. We may take a short recess before starting the 2:30 case, but that's to be determined. Our first case is Allison versus Engel. Does counsel have any questions about our procedures? For purposes of our spectators, if any of you has a cell phone or similar device, would you please turn it off so the lawyers are not interrupted? Otherwise, we're ready for argument in Allison versus Engel.
Does it stop running on its own?
It will start when the bailiff pushes the button.
May it please the court. My name is Bob Tebow, registration 23535. I'm sorry, did you say I need to press the button?
No, the bailiff needs to.
Okay.
Assuming it has been pressed.
Fine. I'm here on behalf of Steve Allison and his brother Barry Allison to ask this court to simply apply the well-established principles underlying Rule 55 default judgment, that it is the harshest of all sanctions, reserved only for the most egregious circumstances. It is not a procedural gotcha trap for the unwary or even the negligent. In the end, it's not punitive, but it's an incentive to enter the courtroom and engage in trial in the merits. Yet contrary to these principles, the trial court below entered a partial Rule 55 default judgment, and that needs to be overturned on three independent grounds. First, there was no default here because the Allisons had filed a motion for partial summary judgment, which simply satisfied the requirement under Rule 55 to otherwise defend. It certainly served to toll any answer date. Secondly, there was also no default here because the Allisons were already present in the courtroom, and they had filed a live pleading, their amended complaint, that separately satisfied Rule 55 for being both a pleading and also otherwise defense to the strike suit, mirror image counterclaims that had been filed. Excuse me. Lastly, the trial court abused its discretion in not fully removing the default because the Allisons moved almost immediately within hours to set it aside under Rule 60 and satisfied every requirement under Rule 60 for that relief. The truth of the matter is that the trial court gave credence to each of these points by reducing the scope of what was originally a full default judgment to be a partial default judgment on only two claims which are left before you. And it's a concept entirely foreign to the fundamental policy of Rule 55. You're either in the courtroom or you're not.
Counsel, can you direct us, and we've looked, can you direct us to any case in which a motion for partial summary judgment, as opposed to a motion for complete summary judgment, has been treated as an effectively a response on the merits under Rule 55A?
We believe the 1962 Welp case sets the general rule in Colorado and explained the logic.
But that was a complete summary judgment, correct?
In that case it was, but the logic we think applies to any summary judgment, including partial, and there's never been a carve-out of that general rule in Colorado case law. The jurisdictions, or the courts in other jurisdictions that have looked at this precise issue, come down clearly holding that partial summary judgments under Rule 55 and the federal equivalent satisfy Rule 55 and prevent default.
And those cases are in your brief?
Those cases are all in our brief, Your Honor. And
well, I don't mean
they
to disrupt
include,
your argument.
Kent v. Guerin, Rent v. Gold, Gortat, Beaulieu, Florida, New York, very significant jurisdictions. But what's important in the Welp case is that the logic set out by the Supreme Court was that, look, an answer is to determine the issues and develop the issues for trial. And the motion for summary judgment, which was satisfactory in that case, was viewed as a means to determine what those issues were going to be as addressed in the answer. And we think that a motion for partial summary judgment is as fulfilling of that policy and that goal as a full motion for summary judgment. And that's why we do think the Welp case, as a general rule, does provide the basis for that point. My time's short, so I'm going to like to start with the first point, but I do want to mention one other thing, and that is the related error, the last error where the court paid over the security bond to the counterclaimants before final judgment. There's no procedure that I know of that provides for that, and I think that needs to be reversed as well.
Well, as I read your brief, though, it concedes that if we affirm on everything else, then there's no harm from prematurely paying out the bond. Did I misread that?
No, I think that's probably right.
Thank you.
In terms of the partial motion for summary judgment, Rule 55 is simple in its requirement. A party must plead or otherwise defend to avoid default. That's it. It's a very broad statement. A formal answer is not answered. Otherwise, the words otherwise defend would not be used.
Counsel, can I interrupt you, please,
Yes,
and
ma'am.
just
Yes,
ask one
Judge.
question? The rule says to plead or otherwise defend as provided by these rules, which is what opposing counsel points out. Do the rules permit response by partial summary judgment? Because it seems that you have to comply with the rules, and I'm assuming the rules of
That-
civil procedure here.
Yes, Your Honor. We think that that phrase, consistent with the other rules, is also broad and flexible. It doesn't specify a particular rule. It doesn't specify a type of pleading under the rules. And certainly, the rules do provide for filing motions for summary judgment, certainly motions to dismiss, and I think it's well established that motions to dismiss or that are filed very early and have matters outside the record attached to them simply become motions for summary judgment under the law.
Under Rule 12, A4C, it says, after the pleadings are closed, but within such time as not to delay the trial, any party may move for judgment on the pleadings. And it says that summary judgment is included as one of those types of motions on the pleadings. But this is pretty clear that it says after the pleadings are closed. So how does that relate with 55's requirement that the response has to be in compliance with the rules? Doesn't that seem to imply that if you read these together, the pleadings have to be completely filed before you can do the summary judgment?
Well, I think there may be other cases, I'm sure there are, but the Welp case itself was dealing with the motion for summary judgment that was filed before the answer date. But I think that the general procedure is that a motion to dismiss or a very early motion for summary judgment is in the nature of a motion to dismiss, but it includes, as this one did, matters outside the record, so it transmorgifies a motion to dismiss with extra things so that the court considers other things in handling, becomes essentially a motion for summary judgment. In this case, it was just labeled immediately a motion for summary judgment.
You acknowledge that there aren't any Colorado cases dealing with partial summary judgment as opposed to a full summary judgment. That distinction, how would the Engels have known that your partial summary judgment motion filed on the date that the responsive pleading was due was really an answer to their counterclaims? And a week later, they filed their motion for default judgment. Why wasn't there a subsequent pleading from the Allisons that, hey, we did file a responsive pleading, look at our partial motion for default judgment, or for summary judgment?
There was, if you remember, the response to the motion for default judgment was in the end a day late due to an arithmetic error. The day the default judgment was issued, which was the day or two after when the Rule 60 motion was filed, there was a response to the motion for default judgment, which was referenced in the motion for Rule 60 relief.
Right,
And
but,
so was filed a day late.
right, but the Ingalls filed their motion for default judgment on October 7th. The court entered default judgment on October 29th. So there's 22 days in there that are going on where nobody, the Allisons don't file anything and say, yes, we did file a responsive pleading. I guess that's what I'm getting at. Since there's no Colorado law that would have put that Ingalls on notice that your partial motion for summary judgment was the response, why wasn't there an assertion that that was the response before the court even got to the point of having to enter the default judgment?
I believe the theory was that the response, the substantive response, did present this point, that the motion for summary judgment was on file and satisfied the Rule 55, and it was admittedly a day late when the math was finally done correctly.
Okay, thank you.
Let me follow up on the math being a day late. In terms of the 60B1, what's the difference between a mathematical error and mere carelessness for excusable neglect purposes?
Well, we think there's some cases like the Plaza del Lago case that speaks of an honest mistake in terms of justifying Rule 60 relief. And in this case, we think it was an honest mistake. I think the Plaza case gave the touchstone that, as opposed to intentional or long-lasting and egregious error. So
But it was
we just think it was
careless.
an honest mistake. As
But an honest mistake is another way of saying it was careless, basically.
Well, I can't say it was careless. It may be a failure to understand the beginning time for the calculation date. I didn't do it, but I'm just supposing. But I think it was an honest mistake as opposed to and it was an intentional interpretation of the rules as set out in the explanation that was filed. I think that was covered by the Rule 60 motion.
Doesn't the Sebastian case say, though, misinterpretation of the rules and of the law doesn't meet the 60B standard of excusable neglect?
The Sebastian case does talk about an interpretation, but in that case, the court did not specify and certainly did not articulate its reason why it thought it didn't match. It simply said it was a misinterpretation. And in that case, it was a misinterpretation. The difficulty in understanding what that case held is that that case held, look, the party had either 1 week or 2 weeks. That was the misinterpretation, but they didn't file for another couple weeks after that. So when they actually filed, it didn't comply with either interpretation. It was just way late. And that's why I don't think the Sebastian case is much of a touchstone for us, because the court did not articulate what went on or why it held it wasn't sufficient. I'd like to reserve, I think I have 3 minutes left, and I'd like to reserve that for rebuttal.
Absolutely.
Unless there are other questions.
You can run the podium down if you wish. There's a switch on your right.
Oh. Yeah, I would like to. On the, you mean the left or?
Yeah,
Oh, okay.
Oh, I thought it was
I
on
think
the
it's on
right.
your right.
I think it's on
it
the
is?
right. A little toggle switch down there in front.
Oh, I'm okay. It's okay. Oh, I didn't. Oh, okay, I see it. Oh, yeah, I would like to bring it down. Thank you. Good afternoon. My name is Linda Lee, attorney registration number 39528, appearing on behalf of my client, the Ingalls. When we were children, we were told sticks and stones may break our bones, but words will never hurt us. And we believe this as children. Words will never hurt us. But as adults, we now know that that's not true, that words are powerful enough to build and empower and destroy it as well. We know that words do hurt. And when those words are commenced and shaped into the form of a complaint with claims launched against you, you have to act. You have to respond. You have to defend against those words. When those words allege that you wronged me, when those words claim that you committed a tortuous act against me, you, with 3 different legal guards standing in front of you, being faced with these claims, being faced with this attack, must defend. Not just morally, not just naturally as we would do if someone accuses us of something, but according to the plain language of the law. The law in Colorado is clear. You must defend against this attack. And failure to do so, having your 3 guards standing before you when this attack is launched, and they do nothing.
Well, it's not, they didn't do nothing. They filed a motion for partial summary judgment.
And Your Honor, I do understand that they filed the motion for partial summary judgment. However, the motion for partial summary judgment did not address the counterclaims. The motion for partial summary judgment was specifically limited, and the trial court actually held a hearing on this. The trial court even indicated, even if read broadly in its findings, even if you construe it liberally, there is no way to say that this response, I think the name gives it away, because it's not dispositive, and I think that's the issue. It was not dispositive of the entire case. The name in itself indicates that they did not intend to address all of the counterclaims. The counterclaims of harassment, the counterclaims of trespassing, nothing in there. It was, even if you try to read it broadly, there's nothing to indicate that it was, in fact, addressing the counterclaims. The counterclaims themselves were not addressed. The trial court made that finding. In fact, wrote it in their order that that they did not address it. And in fact, in addition to that, not only did they not address it, Your Honor, I think we need to really look at the pleadings in this case, because the pleading in this case, if you say, well, they filed the motion for summary judgment, that constitutes a response. Well, then that tells me that their response lacked any affirmative defenses. That response lacked any response to the counterclaims, which were upheld on the default judgment. So one, they were saying originally, if you look at their pleadings, they first said that that was not intended to be their response. And I pointed this out in my brief. Their original response was that that was not intended to be their response, that they wanted that it would automatically toll the time so that they could file a response. So we have 2 different arguments here, and I think that's what we need to be clear about. The first one is that they indicated that they miscalculated the dates and the time, and when they in their motion to respond to the default judgment, they indicated that it was an error in calculation, and the court addressed this as well, saying that the error appears to be based on their interpretation of Rule 6. Their error appears to be ignorance of the law, as opposed to one which addresses, which is an excusable or a mistake or inadvertence. We're looking at a standard here of abuse of discretion. And in this case, the trial court actually went above and beyond to try to look at their motion for partial summary judgment and determine whether or not it actually addressed the counterclaims. The court even held an evidentiary hearing on that to determine whether or not the counterclaims were being addressed. However, the court determined that even broadly read, even liberally construed, that they do not, the motion for partial summary judgment itself does not address the non-water related claims. That's what the court ruled. So if it doesn't address the non-water related claims, which is the harassment, all the claims that were upheld on the partial default judgment after an evidentiary hearing, and the court makes this finding, The question is how do we say that the court abused its discretion when the standard here was, one, they had a duty to respond to the motion for summary judgment, or the motion for default judgment. But in addition to that, that motion in itself put them on notice. And the trial court put this in his written findings. That motion, when it was filed, put them on notice that, hey, you didn't file an answer to all of our counterclaims. Yet still, there was no answer filed. Yet still, there was no response filed to the default judgment. The default judgment, their response was not filed until after the judge granted the default judgment. Then they filed the response.
Did the motion for a default judgment expressly address or argue that the partial summary judgment motion should not be treated as a reply to the counterclaims?
Your Honor, I believe it did. It said that they filed no response, that it addressed the fact that there was just the motion for partial summary judgment filed, but it did not indicate that there was an actual response to the answer.
The countervailing policy, of course, is that default judgments are the harshest of all sanctions.
Yes.
And in this case, when we're considering whether or not to set aside the default judgment, can your client truly claim surprise that they were defending or had a desire to defend the action, given that they filed the complaint and that they filed a partial motion for summary judgment?
Yeah, I definitely think they can, Your Honor.
How?
I think they can because the response, in fact, before this motion was actually, their motion for partial summary judgment was filed. They filed, and this I put it out in my brief, they filed a motion for an extended period of time we didn't oppose that. They filed a motion for leave of time to file, and specifically in their language, in their own motion, their own words, they say, we are requesting an extension of time to file an answer or a response to the counterclaims.
So that just shows that they intended to defend the action, doesn't it?
And what they filed in their answer, and on that date, they said that instead of filing a typical answer, what they filed was the motion for partial summary judgment. So the answer is twofold. Yes, because we are not required to guess at what their defenses would be, and I think the law supports that. I think if we cannot, it would be basically disregarding the entire. You're putting requirements that we had to follow, disregarding all of the rules that require that this be pled with particularity, with specificity. That you are actually responding to the claims, and it must be clear. Your response must be clear. So when receiving the response itself, which they claim was the response to the counterclaims, then in their motion, they said that they would file that. Originally, they said it wasn't, or that's what they originally said, so they could file a response. So they filed this motion for partial summary judgment, yet in it, they don't list any affirmative defenses. In it, they don't address the counterclaims. So if we're just taking you by the four corners of that document, then what we're saying is they're admitting our counterclaims. So that's what notice we received. We received notice that you're not defending against these particular counterclaims. You're defending against, perhaps you're defending against the water claims that, maybe that's what we could be on notice of. And if that's the case, then no prejudice, even if the court found that that would be enough. Then there would be no prejudice because those were not, the default judgment was not upheld on those. We're talking about issues that the court found to be completely unrelated to the filing that they did. So for us to assert and pretend that or us to assume that they're also defending against things that are not mentioned, not addressed, and not pleaded any defense to, then I think that would be unreasonable on any defendant to assume, and I don't know what policy that would create, and I think it could be a slippery slope as to what someone intended to write. There's a difference between having, I say there's a difference between thinking something and saying it when you're thinking it and then committing it to words. When you're writing it down, you're reflecting on it. You're thinking about what you're about to write, and you have time to edit it, you have time to review it, you have time to say, this is what I am presenting to you as my argument, what I believe. And they did that with counsel. And there was no mention of any of these counterclaims that are being upheld. So it's not just saying the first thing that comes to your mind, but it's saying something with thought, with deliberation, with time and artfulness, and that which was said and filed as a motion. And that motion in itself didn't address the claims. And I think it's, honestly, I think it's disingenuous to say that it was intended to address the claims. I don't think it was. And in fact, I think it was really intended, they filed it, and I think there was probably a miscalculation, or for some reason the answer didn't get filed. If you notice, the court says quite often that this was not just once. I can see if this happened once. This was repeated, that they missed deadlines. And the court coined it as cavalier, he said, I don't know if it's cavalier, negligent, or arrogant, but it was consistent. And that was what the court actually put in its order, its written findings. So when you say, we should have known, I don't think that was really my honest review. And I will say I wasn't the counsel on the trial level, but my honest review of the record, it's just clear that was not intended to be their response, although they did request. So they knew, the point is they knew that a response was due on that day. I don't think that was intended to be the response. I really believe that they just, for some reason, their answer was not filed. And it was not filed for another 2 months after that. But what I will say is that I do think that when that response was actually filed, that response was only addressing issues which have not been upheld. Ultimately, the court did have a hearing and said, these are the things I think this is what you're addressing. And so so we don't have a default judgment on those issues. But the case was settled, and the default judgment was entered on the matters that were not unrelated. So I think when you look at the fact that it was clear that they indicated that this was a Rule 6 interpretation. To them, they believed that Rule 6, October 7th to October 28th, normal 21 days from October 7th is clearly October 28th. But they believed, based on their interpretation of Rule 6, that it was October 29th. And that's just, I don't think that you can justify that as being excusable neglect. And I think the case law that I presented in my brief supports this. The court noted Sebastian case, which is clearly on point with that, the Goodman case. There are many cases, but I think even the surprise to the trial court was that there was none of the defenses that they would have had for a Rule 60 motion were asserted. They never said that, we have a meritorious defense. That was never even stated in their Rule 60 motion for relief, which must be stated if that's your defense. And even one of the cases I cited, I'm sorry, it skips my mind at this time, but in my brief, it did say that even a meritorious defense is not enough. It was a Colorado Supreme Court case. I can pull it up real quick to actually say that was, I believe it was, oh, here it is. Yes, it's there specifically. I think it's the Risk case, the Risk v. Air Rental, 315 Pacific 2nd, 820. And what they're saying is that they have to, or that's going to the Rule 60 relief, that they have to establish their Rule 60 relief, because that's really what we're saying. Did the court err and not just err, we're talking about, did the court abuse its discretion And that's the level that we have. And I mean, I cited cases where it says, you know, even if the court disagrees and maybe they were too harsh, the bottom line is that's not the standard here. The standard is not to create policy. The standard is not to disregard all of the rules that have been established by the legislature as to what we have to do, not just them, but everybody. The standard here is, did the court abuse its discretion? And I think the fact that the court, even though they did not file their response to the motion for default judgment, the fact that the court did set aside the default judgment temporarily to have a hearing and have an evidentiary hearing on the matter to try to determine whether or not their motion for partial summary judgment actually could be considered as considered that way. And I think the trial court's findings, I think, are very clear.
Counsel, you're out of time, so if you
Oh,
could,
I
if you could
apologize.
wrap up in a sentence or two, please.
I will say, Your Honor, in a sentence or two, that I think the trial court, in fact, acted with not just in good faith for all parties, but to their benefit. And I think that this appeal has cost my client a lot of time, a lot of money. This is not their first appeal. If I wrote in my brief, this has been expensive. We are requesting attorney's fees, and we hope the court awards it. Thank you for your time.
A few points, Your Honors. First off, the standard here is not only discretion, an abuse of discretion. That is only for the third point. That is our point that the court improperly refused to grant our Rule 60. That is the abuse of discretion. The application of the motion for partial summary judgment and the amended complaint as satisfying Rule 55 is a matter of law de novo. It's a legal matter, not one of discretion. Fundamental to the points, I did want to make this point. We spoke a great deal about the mathematical error, which was terrible, but you will see in our brief that is not the only reason we put forward for triggering the first of the standards under Rule 60. The belief that the motion for summary judgment was sufficient constitutes a reasonable interpretation of law which should justify the proper exercise of discretion to grant full relief. Surprise on the part of the counterclaimants is not the standard either. I believe it is prejudice. And besides fighting to maintain this default judgment in the court, this is not the kind of prejudice Colorado law considers prejudice. In fact, both parties have been put under tremendous strain these many years. This is the result of an improvident default judgment. Colorado law is very clear that default judgments are the harshest sanction, and they should only be issued, and they're saved for the egregious circumstances. Everything we heard from the opposing counsel simply underlines the fact that the trial court misused Rule 55 in a punitive procedural gotcha. It started when it was complete. As we came forward, he peeled it back. But the peeling back, I'm sure, was in recognition of error made. But he didn't go all the way because it was being used as a procedural gotcha. And that is not allowed under Supreme Court rulings. Rule 55 says otherwise defend. It doesn't say response. It says otherwise defend for a good reason, because the language backs up the concept that Rule 55 is to be liberally or very strictly applied, and relief from it to be liberally granted, because we have a system that is based on trial on the merits. You know, this case presents a very simple question of what Rule 55 is for, whether it's going to be punitive or whether it's going to be an incentive. And this court, looking at this case, is the question to very simply answer that question, both for this case and others that might follow. You know, Rule 55 is an incentive to participate. It's not punitive. It was used in a punitive fashion, in a procedural gotcha fashion by the trial court. This is not the course that this court should set for Rule 55, and we think you should reverse and remand, and in so doing so also reverse and remand the premature payment of the monies to the claimants. Thank you.
We appreciate the arguments of both counsel. We will issue a written opinion in due course. Counsel in this case are excused, and when the tables are cleared, counsel in our next case may set up. Our next case is Town of Parker versus Oltman. Does either of you have any questions concerning our procedures? I remind you that the court sent out an order identifying a question that we would be interested in counsel's position. You certainly don't have to devote the entirety of your argument to answering it, and how you address that we will leave to your judgment. We're ready for our argument then. You can run the podium up if you wish.
Thank you. May it please the court. My name is Corey Hoffman, registration number 24920, appearing this afternoon on behalf of the Town of Parker. With me in the courtroom is Town Attorney Jim Maloney and Public Works Manager Chris Hudson from the town. This case is about the Altmans breaching a contract with the town by simply refusing to dedicate a piece of property for a public street, which caused the town to be forced to condemn the property that was required, and then bring a breach of contract claim in this subsequent case to seek damages for the Altmans breach. The trial court's grant of summary judgment was clear error under well-established Colorado Supreme Court precedent. Quite simply, the trial court failed to even mention, let alone distinguish, the case that should have precluded the entry of summary judgment, Osman versus Mountain States Telephone and Telegraph, 520 P. 2nd 738, and cited extensively in the town's briefing. Osman holds that because eminent domain proceedings are special statutory proceedings, a common law claim such as the breach of contract claim in this case cannot be tried in the same proceeding. With that brief introduction, let me respond to the court's question, because it does help frame the issue presented by this case. The court's question asked the effect of the stipulated clause in the final rule and order that just compensation, quote, includes full and final settlement of all claims of any type associated with the acquisition, including attorney fees and costs, end quote. This stipulated clause is not a waiver of the right to bring a breach of contract claim for several reasons. First, the attorney fees and costs referenced in the stipulation, by very definition, must be limited to those of the respondents in the condemnation proceeding, because the term just compensation is a term exclusive and unique to eminent domain and the protections afforded to property owners under Article 2, Section 15 of the Colorado Constitution, and only includes those fees and costs that may be due to respondents. Just compensation has very specific meaning under the Colorado Constitution, as illustrated by the cases of City of Colorado Springs versus Burrell, 658 P. 2nd 280 at 281, and Story versus Bly, 217 P. 3rd 872 at 882. Just compensation can only be due to condemnees in the eminent domain case, and specifically includes litigation costs such as appraisals, because requiring a condemnee to pay those costs would reduce just compensation under the Colorado Constitution. Likewise, Only a landowner is potentially entitled to attorney fees in certain circumstances in a condemnation case. In no case does the condemning authority have a right to attorney fees in a special statutory proceeding. Thus, by definition, just compensation is limited to the money due to the interest holders of record for the involuntary acquisition. Also, the special statutory eminent domain proceeding required the town to name all interest holders of record pursuant to 38-1-102 sub 1. Here, there were 9 other parties, including a lender and several other entities with interests recorded against the property, because a number of transcripts of judgment had been filed against the property. In fact, the motion for entry of final rule and order in this case, found in the record at page 178, acknowledged that the other respondents, not just the Altmans, may be entitled to an allocation of the condemnation award.
Counsel, let me ask you this. Could the stipulation have stated, expressly stated, that the town reserved the right to bring attorney's fees and costs in other actions?
It could have, certainly, but jurisdiction was not conferred in the eminent domain proceeding for the breach of contract claim. So could it have reserved it? It could have said, we may bring another case, but I don't know of anything in Colorado law that would require that affirmative statement to be made in the stipulated judgment, especially because there were numerous other parties that could have been entitled to an allocation of the proceeds in the case.
Counsel, I have a question. When the Altmans didn't dedicate the property, did you have a choice at that point to bring a breach of contract claim rather than a condemnation action? And so was that a strategic choice? And then under the Lindbauer case, which comes way after Osman, that case seems to suggest you can always bring them both and then bifurcate them.
I'll address the breach of contract first and then the Lindbauer case. First, as to a breach of contract case, the Altmans suggest the town could have brought a claim for specific performance or a breach of contract. However, a specific performance decree could not have provided the town with adequate relief because the agreement required dedication of unencumbered fee title. And that's found in the record at page 22. The petition and condemnation, and specifically the allegations at pages 137 and 138 of the record, show the Altmans could not have delivered unencumbered title as promised in the agreement. And a specific performance degree against the Altmans would not have addressed the other interest holders with transcripts of judgment recorded against the property. So specific performance also could not have delivered immediate possession as it relates to the other interest holders of record, which the town needed to build the project when it sought to trigger the dedication requirement, which is reflected in the stipulation to possession starting in the record at page 168. Regarding the Lindbauer case, that was about damages flowing from power lines. And the court, while it severed the case, it also said that all of the damages flowing in that case were related to the condemnation proceeding. That is fundamentally different than this case. The property owners in that case were arguing that there were additional categories of damages that they categorized differently than those that would be available in a condemnation case. And the court said it was premature to decide the case at all because you had to go through all the damage components in the condemnation case. So the Lindbauer case does not stand for the proposition that common law claims must be brought in the condemnation case, which is what the trial court found in this case.
Let me return to Judge Roman's question for a minute. I mean, it's not uncommon to have one action pending and recognize that parties have other claims, and for that reason, settlement agreements are often broadly drawn. I mean, here the stipulation was full settlement, all claims. Didn't just say claims in the pending action or claims in the condemnation action, including attorney fees, which seems to me to at least raise the interpretation that where attorney fees might be an element of damages in some other action, like malicious prosecution, for example, they're a claim, and here all claims, including attorney fees, are being waived. I mean, why shouldn't we interpret that like we would in a personal injury case where you know, the insurance company wants to get a release of everything, whether it's at issue or not, whether it's even imagined or not.
3 reasons. First, this is by definition a special statutory proceeding. That is different from the other cases, whether it be an insurance company case or any other case. This is a very specific type of proceeding that is compelled under the Constitution to provide just compensation. The language in the stipulation, second, refers to, quote, just compensation. And it also refers to, quote, the acquisition. And if you look in the record on page 391, there is a specific reference in correspondence to the fact that the town put the Altmans on notice that it would be seeking reimbursement of any just compensation it had to pay. The correspondence specifically indicated that any dollars expended by the town as just compensation would be sought as damages associated with the breach. Acquisition, and that's the term in the stipulation, voluntary or involuntary, and dedication are 2 entirely different theories. Dedication is by definition a donation or a grant at no cost, and it is this promise to dedicate that the town sought to enforce. And the Altmans were not surprised at the subsequent proceeding, because this had been the discussion the entire time. But the substance of the trial court's error is the holding that the special statutory proceeding not only can be combined with a common law claim, which is directly contrary to Osman, but in fact that the town was required to bring it in the special statutory proceeding. Such a holding is not only contrary to Osman, but also inconsistent with the long line of authorities cited in the town's briefing that identify condemnation as a special statutory proceeding. Put another way, the trial court in a condemnation case does not have subject matter jurisdiction over a common law claim for breach of contract, nor can subject matter jurisdiction be expanded or conferred by agreement. And thus, the trial court erred in finding that the town was barred by the doctrine of claim preclusion. The Polizzi and Jago cases relied upon by the Altmans relate to a very unremarkable proposition, that a dedication requirement can be admissible as an evidentiary matter. The town agrees. However, the town could never be made whole if the Altmans are correct that the breach of contract is subsumed in the condemnation case, because just compensation cannot include the costs and fees incurred by the town in having to acquire the property involuntarily as a result of the breach. The town could never obtain the benefit of the bargain. Even the trial court's order at page 351 reflects the same error. The trial court stated that the dedication requirement could have reduced the value of plaintiff's property. Even if the value of the property was 0, the town would not have been made whole for the breach. Finally, the Altmans assert the town could have raised the dedication requirement as a title issue, and they cite the first place case, 148 P. 3rd 261, and CRS section 38-1-105 sub 5 as a basis for this argument. This is not a case about whether the town already had some color of title to the property being condemned. Your Honors, I argued the first place case several years ago, and I think Judge Rahman was on the panel. A title curative condemnation seeks to determine whether a recorded right to the property already exists that may be disputed. The record in this case reflects that the Altmans refused and would have been unable to execute the deed required by the agreement. A title curative condemnation involves a right that has already been conveyed and the nature and extent of that right. So, for example, in the first place case, the question was whether grants of rights-of-way in 1938 and 39 were sufficient for highway widening. The grants had been made decades ago, and the question was whether a condemnation was necessary, a totally different legal issue and inapplicable to this case. This case is about subject matter jurisdiction. The trial court erred because the court in the condemnation case did not have subject matter jurisdiction. As the preeminent treatise cited in our brief indicates on eminent domain in Colorado, quote, the sole purpose of the statutory framework governing condemnation proceedings is to determine if the right to condemn lies, and if it does, the amount of just compensation that must be paid for the taking of the property at issue. Given the narrow focus of a condemnation action, it has been routinely held that issues that are collateral to its purpose and scope cannot be raised by either party.
Counsel, can I just interrupt briefly? As to that first issue, whether a condemnation action lies, doesn't that rely on whether or not the Altmans complied with the dedication agreement, the annexation agreement? I mean, isn't it that breach of contract that makes the condemnation action lie because they cannot dedicate it without encumbrances?
The case law on condemnation suggests that the elements of condemnation regarding whether or not the right to condemn lies are the things like public purpose, necessity, need. It is not whether or not there was a breach of contract. That is simply not one of the elements in a condemnation case. In many respects, this case is no different than the City of Inglewood versus Weist, 520 P. 2nd 120, in which the Supreme Court held that the City of Inglewood could impose a special assessment on remainder property not taken following a condemnation, because a special assessment was governed by different principles. Here, the town brought a breach of contract claim instead of seeking a special assessment, but the principles are no different. Special statutory proceeding. Thus, the town would respectfully request you reverse the trial court, and I will reserve the remainder of my time for rebuttal.
Good afternoon. May it please the court. My name is Joseph Areno, registration 50499, representing Erica and Joseph Altman. I ask the court to affirm the decision of the district court dismissing Parker's claim for breach of contract on the grounds of claim preclusion. When the Altmans allegedly breached an annexation agreement by not transferring a piece of property for free to the town of Parker, Parker alleges it was denied a contractual right to obtain that property for free. The denial of that right, obtaining the property for free, is the injury allegedly suffered by Parker. With a written contract in hand and the power of condemnation, Parker had multiple avenues to redress its injury, including filing a standalone breach of contract claim. Instead, Parker proceeded in eminent domain and saw the condemnation action through to a final judgment without ever offering the annexation agreement as evidence that just compensation should be zero to address its injury. In the final rule and order, which notably was drafted by Parker and provided to the court by Parker, the court ordered that payment of just compensation constituted full and final settlement of all claims of any type, not just condemnation, any type associated with the acquisition, including attorney's fees and costs. Parker asks this court to ignore the clear language of the final rule and order settling any type of claim because it says it could not raise the issue of its fees and costs in the condemnation action. This is incorrect. First, to address the court's question, in our brief we argue that to the extent Parker has damages, they were settled by this language. We agree with the district court that this language, drafted by Parker and stipulated to by Parker, evidenced an intention to resolve all matters associated with the taking. And further, we agree with the court that it would be improper to address claim preclusion where a settlement agreement exists without making reference to that settlement agreement. And until today, the town of Parker had not addressed that language. Parker may argue that a breach, and they didn't wisely, but the only thing I can imagine is that they would have to argue is that the breach is unrelated to the taking, but that would create a serious problem for Parker's claim for damages. Ignoring this language, Parker argues that it could not address the breach claim based on an entirely novel and incorrect interpretation of Osman, specifically stating that a common law claim cannot be litigated within a condemnation action. Parker hones in on a single sentence that it takes out of context. But instead of taking this sentence in a vacuum, I ask the court to take 3 steps back. 1, to view it in the context of its own paragraph. 1, to view it in the context of the opinion. And a 3rd, to view it in the context of condemnation procedure and jurisprudence. First, within its own paragraph. The court was discussing the requirements of an inverse condemnation action, which may include the requirement of a jury of freeholders, and common law claims have no such requirement. This was raised specifically as one reason that the court made a mistake when it converted Emmett Osman's trespass claim into an inverse condemnation claim. But to the extent that different claims may be filed without disrupting the integrity of the inverse condemnation action, such as through bifurcation as we see in Lineber, this paragraph is not prohibitive. Second, in the context of the opinion, the sentence is not part of the holding. The court did not hold that Osman could not bring his claims at the same time because the court didn't even address that question. The court only held that Osman could not bring his theories, or his theories could not be combined by the court. Another way of saying this is that common law claims, it's not that common law claims cannot be brought within a condemnation action, but that some claims may exist in the alternative. Third, I ask the court to view Osman within the context of 45 years of opinions and condemnation practice since Osman was decided. Parker provides no example of this court or the Colorado Supreme Court citing the sentence it cites to draw such a hard and fast rule limiting the scope of condemnation proceedings. No such citation is made because none exists. In 45 years, Osman has been cited 22 times by this court and the Supreme Court, twice by the 10th Circuit, but never as Parker cites it now, not for this purpose. To the extent that it has been cited, it is generally to say what is not in dispute, that eminent domain statutes control eminent condemnation proceedings, and that a landowner may choose his or her claims just as Parker could have chosen its. Parker's rule undermines condemnation practice and law as illustrated in the cases of Linneber and the Mill, which notably both cited Osman and involved common law claims that were allowed to proceed and exist within condemnation actions because they were related to the taking. Just as in Linneber and Mill, Parker could have filed a breach claim to obtain the property for free, perhaps along with attorney's fees and costs if the annexation agreement provided for them, which it does not. Or, just as in Polizzi and Jagow, it could have submitted the annexation agreement as evidence that just compensation should be zero in order to address its injury.
Well,
Thus-
would
go ahead.
that be dispositive of the injury, though? Because they're also seeking attorney fees.
I take, when I talk about injury, and I'll get into this a lot more when we look at the elements of claim preclusion, but by injury, I'm not referring to all the possible remedies that could be given for a particular situation, but the actual event from which everything arises. And I believe that the injury is the denial of interest in the property, in the parcel, and that when you choose your claims, you choose your remedies, and Parker chose a path that may not have allowed it to receive attorney's fees. So no, it does not affect that issue. Okay. So the operative limitation is not that Osman could not bring both claims, as Parker says, but that he could not recover for both. And the trial court's mistake in Osman was that exemplary damages could not be awarded in an inverse condemnation claim. If Parker's view of Osman is correct, then Emmett Osman could have done what Parker is doing right now, specifically sue for inverse condemnation, obtain a final judgment, and then return to recover in trespass because the damages are different. This is the very thing claim preclusion exists to prevent, the relitigation of matters already settled, injuries already remedied. The law did not prevent Parker's recovery, its choices did, and choices are not an exception to claim preclusion. Because Osman did not establish what claims can and cannot be brought, we look to opinions such as Linneber, which included inverse condemnation, eminent domain, and common law claims all within one eminent domain proceeding. The Supreme Court in Linneber, again, while citing Osman, did not dismiss Emmett Linneber's common law claims in the eminent domain action, as Parker says Osman requires. And yes, Osman and Linneber are both named Emmett. Rather, the Supreme Court allowed Linneber's common law claims to continue within the eminent domain action. The claims, however, were severed, preserving the integrity of the special statutory proceeding as may have been required by Osman. The Supreme Court looked at the substance of Linneber's claims, quote, rather than the form, and it concluded that Linneber's common law claims, quote, dealt with the extent of the taking and were properly included within the proceeding. Matters, even separate common law claims that deal with the extent of the taking are properly included within eminent domain proceedings. Parker's briefs do not address Linneber's facts or holding, even though its breach claim is absolutely related to the taking. In its petition and condemnation, Parker raises the issue of the annexation agreement twice, which defined the area, scope, and purpose of the taking. It also attached the annexation agreement as Exhibit A to that petition and condemnation. At present, Parker alleges that the costs and fees incurred in the taking are damages owed to Parker for a breach of that annexation agreement. For that to be true, then the condemnation action, the taking, had to be a direct result of the Altman's alleged breach of the annexation agreement. Parker's very claim for costs and fees demonstrates the relationship between the two actions. The alleged breach was the cause of and defined this. Did you have a question? No. And defined the scope of the condemnation proceeding, and therefore dealt with the taking in substance, even if not form. Parker's breach claim related to the taking and not prevented by any law is not exempt from claim preclusion. With that, I would like to move on to the two elements of claim preclusion at issue, subject matter identity and identity of claims for relief. First, subject matter identity. This asks whether we're talking about the same thing. The analysis is simple. Even if the forms of the actions are different, could the same evidence be used to prove both claims? The principal case referred to for this is Argus, which was confirmed by Foster in 2017 by the Supreme Court. Argus stated, keeping it simple, that claims concerning the same parcel of real property and same agreements share subject matter identity. The condemnation action, citing the annexation agreement, sought title to the property identified in that agreement. And within that action, as Parker has all but admitted, or maybe has admitted, Parker could have used the annexation agreement as evidence in determining just compensation. Here, Parker alleges that the annexation agreement was breached when the Altmans did not dedicate for free the same parcel of land that they took in the condemnation action. Same agreement, same parcel, the two claims share subject matter identity. Parker says that there is no subject matter identity because it could not recover all of its damages for the condemnation action. But this does not matter here because the question is whether the same evidence can be used in both claims. In its briefs, Parker never explicitly argues that the same evidence cannot be used to sustain both claims, although it does cite the elements of breach of contract. One of these elements is showing damages, and although Parker doesn't say it perhaps viewed in the best light, it could be argued that because evidence of damages is necessary for breach but not for condemnation, that the same evidence can't be, there's no subject matter identity. But under Argus, the analysis is not a piecemeal review of every bit of evidence to ensure that 100% corresponds in each action. Argus could have compared the elements in the minutiae, that it did not. The court did not even ask whether evidence required for statutory reformation, which goes into a detailed analysis of evidence and timelines relative to a 1991 change in the rule against perpetuities, would even be presented in a quiet title action. Argus kept it simple, looks to substance, while Parker focuses on form. Same land, same agreement, same subject matter. In its reply brief, Parker ignored the question of evidence altogether, and instead it argued again that it could not raise the breach claim. Parker cites and mentioned earlier City of Inglewood versus Waste, and states that because the power of eminent domain is separate from the power of taxation and governed by different principles, res judicata did not apply when Inglewood attempted to specially assess the same property that was previously involved in a condemnation proceeding. First, it used the word res judicata. If you look at it, I think we're actually talking about issue preclusion and not claim preclusion in this case, because the matter was the discrete issue of what the word benefit meant in these two proceedings and not an entire claim. Second, and more importantly, in presenting this case, Parker left out significant details about the holding. The court did not, as Parker said, hold that the two proceedings concerned different powers and principles and that ipso facto res judicata did not apply. Instead, after determining that the two actions involved different principles, the court undertook a second analysis of whether those principles meant that the subject matter definition of the word benefit was different. Only after answering yes to the second question did the court find that res judicata did not apply. Finally, onto identity of claims for relief. The analysis here, as I said earlier, is not are the damages the same, but whatever those damages are, do they address the same injury? As I said in the beginning, the injury for which Parker seeks relief is denial of right to obtain a property for free, the deprivation of interest. Parker complicates the analysis by looking at different ways of relief that the injury could be redressed. It looks at damages. But the element is identity of claims for which relief is sought, not identity of relief. Argus again keeps it simple. Identity of claims for relief was satisfied when the injury at the center of both claims was, quote, deprivation of interest in a parcel. In Foster, the Supreme Court stated that claims for relief share identity when they concern all or any part of the transaction or series of connected transactions out of which an injury arose, not damages. While Parker again asks the court to focus on form by restating that it was procedurally barred from raising all of its claims for damages, the Supreme Court in Foster said, we disregard the form of the action and instead look at the actual injury underlying the first proceeding. It may be argued that the additional damages incurred in the condemnation action were not compensable because they did not exist at the outset of the action. However, the 10th Circuit in December in Hogg Tools, while applying Argus, noted that additional damages for breach are only available after a final judgment if the injury that caused those damages occurred after the final judgment. Specifically, there was a second breach, which is not the case here. The denial of the property for free is the injury in both proceedings, and therefore identity of claims for relief is established. I have two things I skipped that I want to touch on before I conclude if the court doesn't have any questions. First, I want to touch briefly on Parker's claim that there is no subject matter identity because the condemnation action was for a public project, while the breach action concerned the Altman's conduct. Both actions concerned both. The annexation agreement referred to the public project, and the breach action, at least if Parker has a claim for damages, is a result of the Altman's conduct or alleged conduct. Also, with respect to any sort of encumbrance, that was only alleged. The Altmans deny that there was an encumbrance. We see no reason that specific performance could not have required turning over unencumbered property. Additionally, condemnation action could have been commenced. Parker could have received possession, and then that proceeding could have been stayed, and then Parker could have proceeded in breach of contract to receive its damages. So there was nothing prohibiting it from doing something other than what it did. So to conclude, Parker cites no legal barrier that prevented it from addressing the injury it alleges, and it incorrectly asks the court to focus on form when claim preclusion analysis specifically focuses on substance. Parker chose to pursue the eminent domain action alone. Parker chose not to present the annexation agreement as evidence of fair market value. Parker chose to draft and stipulate to the language settling all claims of any type, including fees and costs. Parker is here because of its own choices. Thus, Parker's claim for breach of contract is not exempt from the scrutiny of claim preclusion, which it cannot survive. Accordingly, I ask this court to affirm the district court's order dismissing Parker's claims. Thank you.
A couple of very quick points. First, there is no case, none, that stands for the proposition that a condemning authority can receive fees and costs in a condemnation proceeding. Under the Altman's theory, there is no way the town of Parker could ever be made whole for a breach of contract. Second, nothing in the argument addresses the other interest holders of record that filed transcripts of judgment against the property at issue in this case. Counsel indicates it's an allegation. In the record, it has the specific recording information where transcripts of judgment by other parties were filed against this property. Third, in terms of cases that have cited Osman, I would encourage this court not only to look at Ms. Field's treatise, but also the Oslander case, 94 P. 3rd, 1239 at 1241. And finally, if you look at the Lineber case, the language said the claim in substance deals with the extent of the taking, a matter included in the eminent domain proceeding. It was about the damages from the power lines. It was the same issue. Finally, the equities of this case support the town's position. The taxpayers of the town should not be required to subsidize a unilateral decision of the property owner to disregard the consideration paid for annexation into the town. In this case, the promise to dedicate specific property. If the Altmans are correct, the town, and therefore the taxpayers of the town, can never be made whole for the breach of contract by the Altmans. To hold otherwise...
Your time is up, counsel. If you wrap up, your time is over.
Oh, I'm sorry. To hold otherwise would condone the Altmans' bad behavior that makes a dedication requirement in an agreement meaningless. Thank you for your time.
We appreciate the arguments of both counsel. The case stands submitted. We will issue a written opinion in due course. Counsel in this case are excused. Counsel in our third case, Tish may set up. I'm going to check with my colleagues to see if anybody wants a recess. The court will take a short recess, but counsel in the Tish case can set up.
All rise. The court will be in recess.
Good afternoon, and I appreciate your accommodating our brief recess. Does either council or any council have any questions concerning our procedures?
I do, Your Honor.
Yes.
So I talked with some of my appellate colleagues and we weren't sure of a definite answer, but because there's a cross appeal and we're appellees and cross appellants, do we get to reserve time for rebuttal?
You do not.
Okay.
It's 20 minutes for the appellant, split however they want. You get 20 minutes in between.
Okay, thank you.
Any other questions? No questions. To the extent that our spectators may have turned over some since my earlier announcement, if any of you has a cell phone or similar device, would you please turn it off so the lawyers are not interrupted? A final thought, because the parties all have the last names, normally we would not use first names, but you're more than welcome to designate the parties in some way that helps us keep track of them. On that basis, we're ready for our oral argument in the Tisch case.
Good afternoon, and may it please the court. I'm Ryan Sugden, attorney registration number 49499, on behalf of appellants Gary Tisch and the Liquor Barn. With me at council table is Perry Glantz, and in the courtroom is Mr. Gary Tisch. The district court's errors of law denied appellants a fair trial because they were not able to present their side of the story to the jury. The judgment should therefore be reversed and the case remanded for a retrial. First, the district court improperly directed a verdict on appellant's affirmative defense of statute of limitations after the close of evidence, but before the case was submitted to the jury. This court reviews a motion for directed verdict de novo, and the evidence must be viewed in the light most favorable to the non-moving party, in this case, appellants. If appellants have presented a prima facie case in support of their claim, and the facts are disputed, the issue must be submitted to the jury, and the motion must be denied. In this case, the issue is the date on which appellee's claims accrued. Of course, the standard for claim accrual is when appellees knew, or through the exercise of reasonable diligence, should have known about the essential facts underlying their claims. The accrual date is a question of fact typically reserved for the trier of fact. Now, there are 3 limitations periods at issue in this case. 3 years for breach of fiduciary duty, 2 years for civil theft, and 1 year for the damages of trebling of the civil theft claim. That means if there are any facts in the record such that a reasonable juror could conclude appellees knew or should have known about their claims as little as 1 year before they filed suit on April 29th, 2016, the motion for directed verdict must be denied and the issue must be submitted to the jury. Now, there were ample facts in the record from which a reasonable juror could conclude appellees knew or should have known about their claims years before they brought the suit. The first is that appellees had owned stock in Liquor Barn for 35 years. Appellees had hired counsel to assist them in corporate matters. Appellees knew that they could inspect the books and records of Liquor Barn. In fact, they did so on multiple occasions. First, in 2004, through counsel, they requested to inspect the books and records. Mr. Tisch, as majority shareholder, gave them access. They didn't follow through. In 2011, appellees hired new counsel, who turned out to be their litigation counsel at trial. This counsel was retained in an agreement which was withheld until after trial to prosecute a civil claim for amounts owed as a result of ownership of the Liquor Barn. That was the scope of his representation in 2011.
Counsel, I thought in reviewing the record that issue in 2011 related to Gary Tisch's failure to, as personal representative in the estate of his father, to advise the court about a $230,000, I don't know, payment he received. So I thought it was related to the estate case as opposed to Liquor Barn.
There was testimony that there was an ongoing dispute between Ava Tisch and Gary Tisch concerning the estate. But the retention agreement with Mr. Mills stated clearly that the scope of his engagement included to prosecute a civil claim for amounts owed, quote, as a result of the ownership of the Liquor Barn. And that agreement is at page 1,528 of the court file.
Right, but couldn't there have been a civil claim for that $230,000? I guess what I'm not seeing is how the word civil claim in that agreement necessarily is a fact that they knew or reasonably should have known that Gary Tisch was taking profits out of the company and doing other things with them. I thought it related to a failure to notify the probate court about this money.
It is quite possible, Your Honor. However, that would be a question for the jury to decide on what appellees knew at that time or what they should have known. It would be for the jury to decide whether the testimony concerning the probate estate was credible. It would be for the jury to decide whether in retaining Mr. Mills in 2011, and then he did make a records request in 2012, which Mr. Tisch, Gary Tisch, responded, again, giving access, and again, appellees never followed through.
Is there any law that requires them to, when they request to inspect, does a minority shareholder then have to do that inspection if they can't afford it? Is not being able to afford it a reason not to do it? Is there some burden for them to do so?
There is no legal obligation for a minority shareholder to inspect the books and records of a corporation. However, it is a question of their diligence and whether it was reasonable or not for them, with knowledge of their right to do so, and having made 2 requests to do so, they ultimately made a third. Having made 2 requests to do so, it would be a question for the jury to decide whether it was reasonably diligent for them not to follow through. And the example we used in our brief was an individual who doesn't look at credit card statements for 15 years and complains about a fee that was assessed on year 14. They had no obligation to review the records, but it would be a question of whether they were diligent in failing to do so. So this just raises a jury question. And as indicated, they made a third demand on April 3rd, 2015, by Mr. Mills, their counsel. Again, for the third time, Mr. Tisch gave them access, and this time they did follow through with the records request or the review. More than a year later, they filed suit. So from all of this evidence, taken as a whole, a jury could reasonably conclude that appellees either knew or had failed to exercise reasonable diligence in following up, and that they should have known about the facts underlying their claims at least 1 year before filing suit. The overwhelming majority of damages assessed in this case were for treble damages, $900,000.
Counsel, I have a question on the treble damages and that 1-year statute of limitations. Because as I was looking at the record, Gary Tisch testified that they came and did an inspection on April the 15th. Mr. Mills' billing statements indicate that his expert, Mr. Lawson, had everything as of April the 15th. And then the complaint was filed on April the 29th. And the billing statements show lots of conferrals between counsel and the expert in between April 15th and the time the complaint was filed. Is there anything in the record that exists as a matter of law to say this is when the statute of limitations for treble damages began to run? Or do you think that's a question of fact for the jury?
I do believe the accrual date is a fact issue for the jury to decide. I think all of the facts that Your Honor has listed would be bearing on that issue. I'll note that the records you indicate of the counsel's records and discussing with the expert were not introduced at trial. Those were as part of post-trial briefs. So the evidence introduced at trial was that a records request was made, and as Your Honor indicated, followed through on before, at least 1 year before the suit was filed. The jury could reasonably conclude from that evidence that the claim had accrued and was barred. I would submit that Had the issue been submitted to the jury and the jury found in favor of appellants on the statute of limitations and it was challenged on appeal, this evidence would be more than sufficient to sustain that jury verdict. That fact alone suggests directed verdict should not have been entered. The issue should have been submitted to the jury.
Does the claim accrue as soon as like in this case, the expert has all of the records in hand that he needs to make the determination, or when he has sufficiently reviewed the records to be on notice of the claims that are ultimately filed? And I'm thinking, in this case, the civil claim. Is it when he discovered that distributions were being used for, or profits were not being declared as distributions? Is that when the claim starts to run, or is it as soon as the expert gets the record?
I think it's possible that reasonable jurors could reach different conclusions on that very issue, which is all the more reason why it should have been submitted to the jury. Testimony could have been presented that, well, no, they inspected the records, but they didn't have the opportunity to do a true accounting and didn't know about the transactions, and so therefore we didn't know and couldn't have known for months. That would be testimony presented to the jury. The jury could consider it, weigh the credibility, weigh it against all the other evidence, and reach a conclusion on when the accrual date was. All of this suggests the issue was not something on which directed verdict could be entered. And because this really goes to the heart of the case, there were 15 years of damages evidence presented going back to 2001. As a result, had the defense of statute of limitations been offered and submitted to the jury, we could be looking at a very different outcome. The judgment needs to be reversed and the case retried on this issue alone.
Would the entire case be retried, or would we simply have a more truncated proceeding in which statute of limitations evidence was presented to the jury?
Your Honor, I think that the evidence that was presented was spanned from the damages evidence from Appellee's expert spanned from 2001 to 2016. There was no indication in terms of time span of a lot of these incidents and transactions. And then we have the issue of the accrual date for 1 year for civil theft. The civil theft was on distributions, an issue I'd like to get to today. I don't think there's a way to meaningfully parse out that issue, and the case would need to be retried to understand what the scope of damages could be given the potential accrual dates of all three of these claims.
Well, you seem to be reading the statute of limitations as the damages cut off. I mean, if an action is timely commenced, say, BOFD, say within the 3-year statute, that doesn't mean that damages can't have accrued can't be recovered outside the limitation period, does it?
I would agree with you, Your Honor. We did cite case law in our brief, however, that if the claim was not timely brought, damages could be sought during the accrual period, such that it could only go back for a very limited period of time. But if the claim were brought timely, then yes, you could pursue damages from before the statute of limitations period. I think that is another reason why the case would just need to be retried.
Okay,
Are
thank
you unable to tie damages to the 3 different statute of limitations so that whatever the jury would decide on special verdict forms, that would tell you what your damages would be at that point?
Your Honor, I think that would be one way of approaching the issue. It was not done in this case. The verdict form did not identify time periods, did not parse it out, as Your Honor indicates. Instead, directed verdict had been entered before it was submitted to the jury.
Well, the treble were parted out, though. You would agree with that?
Actually, the damages, the verdict form only included 2 claims of civil theft. It did not have a separate line for treble damages because, again, the statute of limitations issue had been dealt with prior to the case being submitted to the jury.
But if the statute of limitations for 1 year, if a jury were to find that was violated, then the treble damages would go away, wouldn't they?
That's correct. If the jury found that the claim accrued more than 1 year before bringing suit, then treble damages would be barred. A claim for civil theft would not be. That's a 2-year standard. But the treble damages would be, yes. The second issue I'd like to address is the district court's abuse of discretion when it excluded the testimony of appellant's expert witness. This was an expert-driven case. There were 4 expert reports that were issued, 2 by appellee's expert in November, a supplemental, then in January of 2017. Appellants responded with expert reports initially in December of 2016, and then again in February of 2017, a supplemental rebuttal. There was no pretrial motion to question the admissibility of any expert testimony.
Did anybody request that pretrial?
There was no request for a pretrial hearing.
Okay, so because I know you raised the Shrek case in your brief, but I didn't see anything in the record where that was ever requested.
Pre-trial, there was no request for a Shrek hearing. Appellees never filed any motion to challenge the admissibility of appellant's expert witness. This was first raised after appellants had qualified their expert witness in the areas of taxation, QuickBooks, and accounting. It was only then that they cross-examined Ms. Muller, Catherine Muller, the expert, using a document which had never been disclosed, challenging the basis of her opinions, and contending the only testimony that was ever discerned was testimony concerning a $4,402 automobile expense that Ms. Muller ultimately testified was she reclassified. She did not add it, she reclassified it, recoded it. And on that basis, which the district court ultimately found was perjury, the inconsistency in her testimony, inconsistency which goes to credibility, which is in the province of the jury once again.
Didn't the court make that perjury finding, though, in the post-trial motion? As I read the testimony on this expert, it seemed that it was a surprise to everybody that the court questioned her, did you manipulate these records, not into real specifics, and that it was really based upon her manipulation of the records after plaintiff's expert had already reviewed those records. That seemed to be the basis, and I didn't read that there was an objection at that point. And by Gary Tish's counsel, and then in closing argument, Gary Tish's counsel concedes that the court properly excluded the expert. So I'm wondering how this issue is even before us on appeal.
Well, there was an objection at the time of the cross-examination during the voir dire. Mr. Tish's counsel did indicate that he opposed her exclusion. He did then take testimony, redirect testimony, outside the province of the jury. The jury had already been excused, so they did not get the benefit of hearing Ms. Muller's rehabilitative testimony that she did not intend to make any changes, that in fact she only changed codes. And they also did not hear her offer to review every one of those transactions to ensure that her opinions were still reliable. What the district court failed to do was the proper analysis under Rule 702, which is are the opinions the expert is going to give reliable and helpful to the trier of fact, and is the expert qualified, which is undisputed.
Well, counsel, the jury may not have heard that, but what they did hear in the closing argument from Gary Tish's counsel was, quote, "I'm very embarrassed that she did it, and I'm sorry we couldn't have her testimony. The court properly ruled that she was not allowed to testify to you, and so we don't have any expert testimony." Correct?
I agree with the court's recitation.
That instead of fighting it, you waived that argument then, didn't you, for our purposes?
Well, I think for appellate purposes, to preserve an issue, it needs to be timely brought to the district court's attention. And there's no talismanic language that's necessary. This was certainly challenged at the time, and it was certainly challenged in post-trial motions on an error of law. Closing argument, again, which is not evidence, but is an opportunity for counsel, frankly, to try to put their best foot forward and to try to present their case in the best light possible. Appellee's counsel in closing argument had used her exclusion to cast a pall over all of appellant's evidence. They said, you didn't hear her testify, and the reason why is, in effect, I'm not quoting, but in effect, she cooked the books. And her rehabilitative testimony was clear, she hadn't. The jury didn't even get the benefit of hearing both sides of the story on a witness who didn't ultimately testify substantively. This issue is extremely prejudicial. I would contend that it was preserved timely by opposing it at the time. Closing argument, counsel was simply trying to put the best foot forward, and it was again preserved in post-trial motions. I would also like to briefly touch on the fact that there can be no claim of civil theft in this case because Gary Tisch is the sole voting member and majority shareholder. Under the articles, he has the sole discretion to manage the corporation's affairs. In the exercise of that discretion, he, of course, owes a fiduciary duty. There were transactions that appellees challenged. They claimed were improper. They claimed he was not impartial. He benefited from them personally. But at no time was there any testimony or any evidence that appellees had a proprietary interest in any of those funds. The funds went from Liquor Barn to various corporations or entities or individuals. They can contend those transactions are wrongful. That is absolutely a claim for breach of fiduciary duty. What it is not is a theft, because
Is it your position then that the court's basically ruling at summary judgment that whether these profits that were used for different purposes constitute a distribution is not a question of fact for the jury, and that a distribution can only exist if it is formally declared as such?
for purposes of a civil theft claim, the issue is whether appellees ever had a proprietary interest in the funds that they're claiming were stolen. There was no evidence on summary judgment, and again was moved in directed verdict post-trial before the case was submitted, that there was no evidence presented, that they never had any interest in those funds.
But Mr. Lawston said, yes, I would classify these as distributions, and minority shareholders have a proprietary interest in distributions. So that was the basis, obviously, for the jury's verdict here. Are you saying that as a matter of law that is not a question of fact, that it should be, you can't say this is a distribution unless you have a formal declaration?
We are saying that for civil theft, as a matter of law, if the declaration has not been declared, you don't have a claim for civil theft. What you do have is a claim for breach of fiduciary duty. The testimony from Mr. Louston may be transaction A was improper because these should have been excess funds. These should have been distributions, and Mr. Tisch should have exercised his discretion and distributed as such. That was a breach of his broad discretion under the Articles of Incorporation. But at no point in time have they ever had a property right so they can state a claim of civil theft.
Are you aware of any cases that say you have to formally declare a distribution for it to exist?
I am aware of no cases on that precise point. What we did cite was copious case law that a civil theft claim only lies if you have a proprietary right in the property allegedly stolen. And to find that here would have to retroactively change transactions that happened years, if not decades, in the past. And that would expose directors of corporations to extreme risk of liability for thefts concerning transactions that were authorized at the time and they believed were proper at the time.
Your time is exhausted.
Thank you.
Good afternoon, Your Honors. May it please the court, my name is Michael Mills, attorney registration number 34859. I represent the appellees, Dan and Eva Tisch in this case. With me at council table is Shar Aiken. Your Honor, I'd like to address briefly appellees' cross appeal on the arbitrary cap on recoverable costs. By statute and by rule, Colorado law is that a prevailing party shall be entitled to recover reasonable costs. We acknowledge that a judge has the power and the discretion to limit what it finds is reasonable. Unfortunately, that was not the case in this trial. No finding about reasonableness was made. In fact, appellants initially conceded that the costs were reasonable until they found the prior judge's earlier ruling stating that, or really it was in the case management order, stating that she was going to put a cap on, but the cap could be modified subject to later motion. Well, I'm not sure at what point those costs exceeded the cap. They certainly were exceeded, at least during the run-up to trial and the trial itself. Mr. Louston, as the court noted, not only testified for a day and a half, but stayed because the entire thing was an accounting case, stayed for the duration of the trial because he alone understood all of the accounting and where the documents and the math was.
So shouldn't you have moved at that point for relief from the cap for expert fees?
Well, Your Honor, quite honestly, as we were running up to trial and going through the trial, I wasn't getting daily updates on a bill, and I'm not sure when we passed it. We didn't even realize it until we submitted a bill of costs, and nobody, including appellants, appellees, or the judge, recalled that there was a cap. And initially, appellants withdrew any objection and conceded that they were reasonable, only to come back the following day with the arbitrary cap. Our bill of costs was our motion saying, these are our costs, they are reasonable, we think we should be allowed to exceed that cap. And that was really our first opportunity, because we had to get that final billing from the expert following the trial. And so it required, under Colorado law, it requires a finding of whether they're reasonable or not. And when the other party has conceded that they're reasonable, imposition of an artificial cap that was put on this case at the very beginning days of the trial, before anybody had any clue how many businesses were involved in these circular accounting mechanisms, how many 40 or 50 banker's boxes of documents the expert would have to review, is improper, and it does not properly allow the appellee in this case to recover their reasonable costs.
Go ahead.
Does Rule 16 expressly empower a trial court to set such a cap?
No, Your Honor, I don't believe it does. It allows the trial court to award or to make findings about what fees or costs are reasonable, and to only award those that it finds are reasonable, but it does not, there is no language, and to my knowledge, we've found no case law that would support an artificial cap without any relation to reasonableness. In this case, the judgment was for over $1 million, and as counsel just noted to the court, this was almost entirely an accounting case by experts, and that expert charged, I think the total bill was around $60,000 on a $1 million case. By any measure, by appellant's agreement, or by the amount at issue, or by the complexity of the case, or the risk of failure in prosecuting the case, those costs were all reasonable. And the court should have made findings one way or the other, even if it were going to limit the costs it found were reasonable.
Counsel, was opposing counsel's concession that Mr. Louston's expenses were reasonable? Is that the reason that there was no request for hearing on reasonableness?
Yes, Your Honor. Any other questions on that, Your Honors?
No.
Okay. Next, I'd like to briefly touch on declaratory relief. Early in the case, summary judgment was granted against appellees with regard to their request for declaratory relief to determine the number of shares and the type of shares that the appellees had. Dan and Eva Tisch, in this case, the appellees, were not aware that they had 1,600 shares of stock each that were all voting stock. There is no testimony or evidence in the record that they were ever aware of the nature or the number of shares they had until the record inspection was done in 2015. That's when canceled stock certificates were found. That's when they first discovered that there had been an amendment that allowed them to convert, it was supposed to allow them to convert 7/10 of each voting share of stock to voting stock, and 3/10 of each share of voting stock to non-voting stock. And it was only after the inspection, and really it was months after the inspection, because it took the expert quite a while to go through all of these documents and try to figure out what was going on. And at that point, we weren't his only case and weren't a very big case.
Counsel, I have a question about that, because the letters from 2003 and 2004 established that the Tisch siblings, Dan and Eva, were aware that they had non-voting stock, okay? Because that's clearly in there, but they don't establish numbers, no numbers of shares. So are you still contesting that they didn't know that they had non-voting shares?
Your Honor, what I'm contesting is that the proper issue was never addressed or decided by the trial court. What those letters reflect is simply the appellee's acceptance of what they were being told by the appellant. They were constantly being told that they only had 10% and they only had non-voting stock.
Right, but
And they're-
doesn't that put them on notice that if they felt that something different was the case, that they should say something at that time?
No, Your Honor, because they didn't know that their stock used to be voting stock. They didn't know that there was ever an amendment that converted their stock. They had a right and a voting interest and a right to notice on everything. And it was admitted by the appellant, and it was admitted by all parties. There's no contradictory testimony that they were never given any notice of the amendment that specifically converted their voting stock to non-voting, and did that even improperly. They were still supposed to retain voting stock and have notice of everything, and instead, all of their stock was converted to non-voting. They didn't know they had voting stock. They didn't know what their rights were, or the number of shares, and instead of a number of shares, they were just told that they had 10% non-voting stock. It's admitted that the change was never presented to them, and they were never given notice of a change or the fact that they had the voting rights in the first place. So you can't look at their acceptance of what they're being told as notice that some improper change had occurred that took away their property rights, took away their voting rights, diminished the number of shares of stock they had. And that's the problem with the summary judgment on that. There is absolutely no evidence in the record. In fact, it was admitted by all that they did not get that notice. They did not know that a change had ever taken place, and they certainly did not know that the change by the liquor barn had been improperly executed, both reducing the number of shares and converting 100% of their stock to non-voting. And so that change of which they weren't given notice, the notice to which they were entitled, then became the basis to never give them notice of anything again in the future. And the appellant testified on the stand that he never gave them notice because his attorney told him he didn't have to give them notice after the change. No one ever explained why notice of the change was never given to him, although it's admitted it wasn't. So summary judgment on that issue was improper because the evidence was that they accepted what they were being told, but they had no knowledge and no evidence of the change, of the improper execution of the change, or the reduction in their shares.
Well, the correspondence referenced by Judge Freyre deals with non-voting stock. Is it your position that the siblings never were aware that they used to have voting stock?
That's correct, Your Honor. They did not know. This was a family business. The father started a liquor store. He had given them each 1,600 shares. They didn't know what they had or what their rights were. Their dad ran it. They, quite honestly, I think were either teenagers or young adults at the time and were unaware of any of that.
At that summary judgment, did they put in affidavits to the effect that they had no awareness of voting, non-voting?
Yeah, they testified to that, Your Honor.
Well, I don't want to get the trial testimony and the summary judgment mixed up. At the summary judgment stage, did they put in affidavits denying that they knew that they had ever had voting stock or the difference between voting and non-voting stock?
I believe they did, Your Honor. I would honestly have to go back and check the record. That was many years ago.
Go on, please.
But simply a finding that first of all, they didn't even acknowledge it. It was their attorney at the time negotiating in regard to the father's estate and trying to negotiate a sale of their stock. The attorney parroted back that they had 10% non-voting. There's no evidence that that was ever communicated to them. He was trying to get a value. He requested records because at the time, Gary Tisch was going to purchase their stock, and then when they requested the records, at some point thereafter, he changed his mind, didn't want to purchase it. That was never pursued again. He directed his attorney, this is in the record, he directed his attorney, or it was in the letter, not to address the requests and to require the appellees to go directly to Gary Tisch to figure out what their stock was worth.
Counsel, It's your argument, and so you can argue it the way you'd like, but I will let you know that I'm very interested in the statute of limitations issue, if you would cover that at some point.
Statute of limitations issue, yes, Your Honor. Statute of limitations issue,
And the accrual.
the accrual date. Your
Why
Honor,
why wasn't that an issue that should have gone to the jury?
Because there was no evidence in the record at all on which the jury could have hung their hat to find that statute of limitation. First of all, there's no case law that requires the appellees to actually go forward with an inspection once they ask for one. Each time they had requested an inspection, it was for purposes of valuing their stock for the purpose of a sale. The first time, that sale fell through, so they didn't pursue it. The second time they requested to inspect the records, they were told they had to have an accountant or a valuation expert to look at this business and determine what they're worth, because a stock certificate alone is not going to tell you what your stock is worth or enable you to make an informed sale of your property interest. So in both of those cases, they didn't go forward. There is, as counsel admitted, there are no cases that require them to, and there is no evidence that they were on notice of any facts that would have required that they go through with that.
But a third piece of that dealt with the treble damages, which was a one-year statute of limitations. Why wouldn't that be a jury question?
Your Honor, first of all, they never objected or argued that there was a one-year statute. They were arguing about the 2- and 3-year statute in the record, so the judge never got to address whether there was an issue of a 1 year on trebling. That didn't come up during the trial. Second, what did come up was the amount of time that it took Mr. Louston to go through these voluminous records. And we got the initial records from the company, and then we had to, over a long period of time, get more records. And so Mr. Louston did not even know or identify what potential claims were until much later. It wasn't until at least a month after he got the records that he was able to say, there's something wrong with these financials. When he looked at, I forget what the number is, the $38 million in revenue over the extended period of time and only $50,000 in profits.
And I guess my question is, why wouldn't it be the jury's role to decide at this point, you should have known?
Because this, Your Honor, honestly wasn't argued or brought to the court's attention. This is something after the trial's over and after the argument on the directed verdict and after post-trial motions, this is something that was created for the first time, saying, oh, there's a 1 year that should have gone to them. They didn't give the court an opportunity to rule on that. They didn't give the court any argument or support for that being the case.
So it wasn't raised as an affirmative defense or anything along those lines?
No, Your Honor. To my knowledge, the 1 year was never raised.
Well, the trial court initially denied Gary's summary judgment on the statute of limitations, correct?
That's correct, Your Honor.
Okay, now that's not a separately appealable order. Are you saying that in the summary judgment, there was no reference to the 1 year statute of limitations on trebling?
To my knowledge, there wasn't, Your Honor, and that after the complete trial, there simply wasn't enough in the record to go forward on what they had presented.
Well, okay, then, and I'm just using the first name, then Gary's lawyers moved for a directed verdict, correct? On the statute of limitations.
Okay, we've got a couple of issues here, Your Honor. I believe that the directed verdict was on, I don't think they moved for directed verdict. They wanted to submit, if we're all talking about the same issue, Gary Tish's attorneys wanted to submit the statute of limitations defense, and the judge, I believe sua sponte, took it away from them and
I
ruled.
apologize, I misspoke. Okay,
Okay.
so the judge essentially grants a directed verdict against Gary on the statute of limits.
Yes, Your Honor.
Okay. And you're saying that was there argument to the trial court at that time?
I believe we did have a small hearing about that, Your Honor.
And you're saying, as best you recall, that there was no reference to the 1 year statute of limits for troubling at that hearing?
I am confident that that is correct, Your Honor. I don't recall ever hearing argument about a 1 year until the appeal.
Okay, thank you.
Your Honor, I'd like to briefly touch on Ms. Moeller, appellant's expert. The Shrek defense was never raised at trial. That was not something the trial court was ever given an opportunity to rule on. However, the trial court has the duty and the power to determine what evidence comes in, whether it's under 702 and whether expert testimony would be helpful to the jury, whether it's under 402, whether it's relevant, and whether it's under 403, that the danger of unfair prejudice outweighs the probative value. In this case, Ms. Moeller testified that she had never made any of the accounting entries, never changed the accounting entries, had never done any accounting for them prior to her engagement as an expert. She testified that she knew it would be wrong to do so because she was opining as an expert. And then she admitted one after another, she admitted making multiple changes. One of them was over $400,000. And counsel has painted that as simply switching a code, but switching a code changed a $400,000+ entry from, I'm not an accountant, but essentially from an asset to a liability. So on the books, that makes an $800,000 difference in what's reported, whether there's profit, what's going on. Appellee's expert found this in the days before trial. We had been given an access to the QuickBooks, went back in, and he was just confirming after receiving her expert report, was going back in just to check on things and realized that numbers had changed. Part of his report dealt with improper payments to Mr. Tisch's, appellant's personal car by the liquor barn that should not have been company expenses. Her report says, no, that's absolutely wrong. It's properly accounted for, and points to the page, but she points to the page she had changed. And so you have an issue of whether her testimony is helpful because she's changed the records on which she's opining. She's changed the basis on which no payments were ever given to the appellees, and has then issued an opinion. You also have an extreme danger of unfair prejudice when you've got an expert who relied on the historical records, and she is trying to impeach his opinions by saying, oh no, it's properly accounted, he's absolutely wrong, here it is, but it's only that way because she changed it. That prejudice alone should have disqualified her from testifying. And she testified, no, I didn't make changes. We showed her the first one. She said, well, okay, maybe that, but I didn't make any others. Showed her the second one. And then she admitted that. And the judge did grill her at length about the fact that she was changing the records on which she was opining. It wasn't argued, but in the briefs, there was an issue about whether there was evidence in the record that supported the award of damages. I think clearly the record shows that there was more than ample evidence in the record. The record shows.
Let me ask you a question on that.
Yes, Your Honor.
What's the difference between this, forgetting about trebling, what's the difference between the breach of fiduciary duty damages and the civil theft damages? I mean, it would seem to me that if Gary somehow misappropriated dollars from the company, those dollars or your client's percentage of them are the damages. So how can the jury come up with a different number?
Your Honor, I can't get into the jury's mind. I don't know which evidence they looked at and found fit the jury instructions in either case. They were given a lot of information about payments to his credit cards and his Belize trip and directly for his truck, and they were given information about payments to other unrelated companies. The appellant did not request a reasoned jury verdict or special interrogatories or anything. We can't know which evidence they used. Simply that there was more than ample evidence in the record to support the finding. There was $32.8 million in revenue over a period of time, and the industry, in the record, Mr. Lawson testified that the industry margin for these liquor stores of a like size and revenue, the margin would be 25.9% to 26.4%.
Okay, and your time's up, and you've answered my question.
Thank you, Your Honor.
We appreciate the arguments of both counsel. The written opinion will be issued in due course. This case stands submitted. Since our afternoon docket is complete, the bailiff may announce a recess.